People often ask, what is the best way that I can defend myself in my battery case? One way people believe is the best to help themselves is witnesses. And witnesses can be very valuable. If you have someone that was there at the time of the battery, saw what happened, and knows that you didn't commit a battery, or will relay it in a way that explains that it was not legally a battery, they'll be very helpful. Just keep in mind that sometimes there's video, there might be audio recordings, or other things that can cause problems with those witnesses. Additionally, if your witness is someone that you're close to, for example, a boyfriend or a girlfriend, and things don't work out, they may change their mind. So you need to talk to an attorney quickly so that we can preserve any of those witness statements and you're able to be in a position to make the best defense possible. When it comes to defense in a battery case, you want to consider how to attack the credibility of the prosecution's witnesses. Sometimes that can be done by their ability to observe. If the witness is a neighbor who is looking through a bush, they might not have had a chance to see what actually happened, or maybe they only caught the tail end when you were winning that fight. A witness's memory can also be challenged. You can bring up the fact that the witness doesn't remember everything, or maybe they remember certain details inaccurately, or not how the evidence shows that the event occurred. And if that happens, you can attach that credibility issue to other testimony in the case. Keeping in mind that when a witness is involved in a battery, their emotions are running high and they're also upset. So sometimes we can use the fact that they're angry to show that they may be biased in the way they recall that story. When there's a battery with a deadly weapon, you may want to bring in a ballistics expert or a fingerprint expert or someone who can testify that the state's evidence is not accurate. We also may bring in an expert on a battery with substantial bodily harm. Battery with substantial bodily harm requires just that, substantial bodily harm. So we may want to bring in an expert who can testify about the initial findings or about the victim's testimony that can say that this is not a substantial injury or that it was caused by something other than the battery. And lastly, and on occasion, we will bring in a DV expert who can talk about why it was not battery, but instead it was self-defense. Because sometimes, even if you're not the initial aggressor, it can be a reaction to prior things that have occurred. Whether or not an expert can be used in your case is very fact-intensive, because sometimes they will be beneficial and sometimes they won't. The good news is we can get an expert's report or opinion prior to notifying the state that we intend to use that expert, so if the testimony doesn't help us, we never have to bring it up. One thing you should never do is intimidate any witnesses. If you intimidate witnesses, that's a new criminal charge. If you're charged with a misdemeanor battery or a misdemeanor battery DV, intimidating a witness or attempting to influence them is actually a felony. So you're making your case significantly worse and adding charges that have more severe consequences. In addition to that, you lose credibility and they gain more momentum. Whether it's a felony or a misdemeanor, if you're trying to convince a witness not to testify, it's usually not looked upon favorably. There are many ways to present a battery case to a judge or a jury. Witness testimony is one of those ways, whether it's presenting our own witnesses or going after the credibility of other witnesses. Either way, you need legal help so that you know what evidence is admissible and which witnesses are actually beneficial to your case. Give us a call and we'll strategize with you about how to best protect your rights.